In this installment of Washington Legal Foundation's LegallyBrief, we are joined by Stephen Bradbury, a partner with the law firm Deckert LLP and former head of the Office of Legal Counsel at the Justice Department, who will give you his thoughts on the Federal Trade Commission's recent decision to withdraw a 2003 policy statement on the use of monetary remedies and disgorgement in competition cases.
On July 31st, the Federal Trade Commission announced a major change in its antitrust enforcement policy. The agency withdrew a policy statement it had issued in 2003 that governed when the FTC will seek what are called monetary equitable remedies in antitrust cases. As a legal matter, these remedies are different from the more familiar money damages or civil fines. The FTC has no authority to impose money damages or civil fines directly for antitrust violations. Instead, the FTC's power in the antitrust realm is equitable in nature. The FTC has authority to issue cease and desist orders and to seek injunctions governing future conduct. But courts have held that this equitable power also includes the authority to impose the traditional equitable remedies of disgorgement and restitution. Disgorgement means the forfeiting of profits unjustly earned. And restitution means the return of money to victims who lost money because of the unjust conduct. Obviously, these forms of monetary remedies can add up to very substantial amounts of money, depending on the nature and duration of the alleged antitrust violation. In fact, in some cases, they can be much greater than money damages or civil fines. Back in 2003, following public notice and comment, the FTC issued a policy statement declaring that as a matter of enforcement discretion, it would only seek disgorgement and restitution in exceptional cases. The 2003 policy statement laid down 3 factors that would guide the agency in identifying those exceptional cases. First, under the 2003 policy, the antitrust violation would have to be clear before the agency would seek disgorgement of unjust profits. That meant that the violation would have to involve serious conduct that a reasonable person would understand was prohibited under the antitrust laws, like price fixing or intentional efforts to destroy competition without any justification, or intentional acts to hide the violator's tracks, such as by misleading the agency or failing to produce relevant documents. The FTC explained that if the conduct at issue is novel, or if there are colorable arguments to defend it, then disgorgement of profits would be unfair and wouldn't appropriately serve the goal of deterrence. Second, the FTC said that it would only seek monetary remedies where the amount of the disgorgement or restitution could be definitively calculated. That's a factor that courts have applied and that they will continue to apply in deciding whether these remedies are appropriate. And third, in 2003, the FTC said that it would only seek these remedies, particularly restitution, where it had reason to conclude that other forms of monetary recovery, such as treble damages in private antitrust suits, would be inadequate to address the violation. That could be the case, for example, where the real victims who lost money from the conduct are precluded from seeking damages, such as where they are indirect purchasers who don't have standing to sue under federal law. Now, the FTC has abruptly withdrawn the 2003 policy statement. It did so without any public notice or opportunity for public comment, and over the dissent of Commissioner Maureen Olhausen. The FTC justified the change on the ground that the 2003 policy was overly restrictive, though the agency didn't describe any cases where its enforcement efforts have been hampered. In announcing the change, the FTC specifically said it would no longer limit disgorgement to cases where the antitrust violation is clear. since courts have not required such a condition. This change strongly suggests that the FTC would consider seeking the forfeiture of profits even where the activities at issue involve novel issues and even where there may be colorable arguments supporting the legality of the conduct. That prospect is troubling, among other things, because it could dissuade companies from entering into innovative new business activities or from zealously defending arrangements that raise issues under the antitrust laws but that might prove to be pro-competitive. The FTC also explained that it will no longer restrain itself from seeking restitution or disgorgement in cases where other forms of effective monetary recovery may be available, such as damages claims by private antitrust plaintiffs. In her dissent, Commissioner Olhausen objected that this action will now leave businesses with no effective guidance as to when the agency will seek what could be very substantial monetary remedies. The enforcement record doesn't provide that guidance, since these cases have been rare in the past. That the FTC acted so precipitously to withdraw the 2003 policy without taking the time for public notice and comment, and without developing a record to support the decision, suggests that the agency may intend to put this new, more aggressive enforcement posture into use in the very near future. Perhaps the agency already has some class of cases in mind for seeking monetary remedies. One area of enforcement priority for the agency, for example, has been its pursuit of so-called pay-for-delay settlement agreements in patent disputes between brand-name drug companies and generic drug makers, an issue that certainly doesn't involve a clear violation of the antitrust laws, since the agency has lost these cases in a number of courts of appeals, and the issue now looks like it may be heading for the Supreme Court. The FTC might be thinking of those cases as a candidate for this new enforcement policy. Whatever the agency's intent, the bottom line is that we can expect the FTC to pursue disgorgement of profits or restitution more frequently from now on.